Okay, folks, time is approximately 6 p.m. and February 12th, 2026. Farragut Board Mayor and Alderman meeting will now begin. Good evening, ladies and gentlemen in attendance and online. I want to thank you for your presence at tonight's Board Mayor and Alderman meeting. My name is Ron Williams, the fourth elected mayor, town of Farragut. We appreciate that each of you has taken your time from your busy schedules to either attend or view tonight's meeting, see how our town government works. All Farragut Board and Alderman meetings are public notice per Tennessee state law. All board meetings minutes are taken and are available at a later date. Each will be recorded and can be viewed on YouTube. If you're in attendance, you should be able to pick up a copy of tonight's agenda at the door when you came in. If you are not able to attend tonight and are viewing from home, then the agenda is available online at our website. For those in attendance that would like to speak, please pick up a blue card at the door, write your name and the agenda number that you wish to comment on, and bring it down to the town recorder. There will also be time reserved near the end of the meeting for citizens forum comments on non-agenda subjects, which also requires you fill out that blue card and bring it down to the town recorder. And just put on our citizens comments if that's when you wish to speak. On each agenda item, the mayor will ask the town recorder for the residents' input. During that time, any Farragut resident wishing to speak to the board on that specific agenda item may do so for up to 3 minutes. After being recognized by the mayor, please go to the podium microphone in order to be heard and viewed by all. To conduct efficient, business-like meetings, the town has adopted rules for how its meetings will be conducted. Primarily, these rules are designed to keep the meeting moving and assure that all points of view are heard and considered, and also to provide common courtesy to everyone. We ask that you observe the established meeting rules when addressing the board. At the beginning of each presentation, please state your name and address for the record. We ask that you address all your questions to the mayor or his absence, the vice mayor to my right. Do not direct questions to the alderman or staff members. If necessary, the mayor may call on an alderman or staff member concerning your question or comments. Once you've given your input, please return to your seat so we continue with the meeting. We ask that every speaker avoid use of improper language, profanity, or other inappropriate conduct and address issues, not individuals or personalities. Speakers should strive to avoid redundancy and should have their own original viewpoints. We ask that you also please stay on topic. Okay, meeting call to order. We will start tonight with a roll call by our town recorder for a quorum.
Alderman Kane.
Here.
Alderman LaCroix.
Here.
Vice Mayor Meyer.
Here.
Mayor Williams.
Mayor Williams here. Thank you. We do have a quorum. Now please join me by standing for a silent prayer in honor of our veterans, followed by a pledge of allegiance to our Scouts, you can take it off here. Okay. Do we have any agenda amendments?
No, sir.
Move to approve. Second.
Okay. Motion made by Alderman Meyer, seconded by Alderman Kane. If in favor of approval, please say yes.
Yes. Yes.
Let the record show February 12th, 2026 agenda has been approved as posted. Any amendments to our minutes?
No, sir.
If none, I'll ask for a motion.
Move to approve. Second.
Motion made by Alderman Meyer, seconded by Alderman Kane. If in favor of approval, please say yes.
Yes.
Any noes? Let the record show the minutes have been approved as posted. Thank you, guys. Mayor's report. I want to start by thanking Drew Burnett for reading the Farragut Board Mayor and Alderman's resolution at the Tenova Hospital on celebrating the National Red Day for Women's Cancer Awareness. Also, the next was a special event for Drew and his family for the Sports Hall of Fame, where Drew was inducted into the Hall of Fame for town of Farragut, or for the Farragut High School. He was inducted right beside Coach Eddie Courtney. Two more items to report will be the first being the Public Works first responders on clearing the downed limbs in the area that lost power, along with the superb effort that it took to tackle the changing ice and snow conditions that we were faced with during the last January storm. They were prepared and they were equipped. Also, the Museum Committee on the presentation of Black History Month celebration that was held this past Sunday at the Community Center. There was a great crowd that was enjoyed by all. We'll move on to Alderman reports with Alderman Burnett temporarily out. I'll move on to Alderman Kane.
Thank you, Mayor. When we had the storms back in January, I took the advantage of riding with Will from Public Works, and we rode around town, and he pointed out the areas of concern when it came to the snow and ice that we were going to have, and got to see a lot of the gentlemen from Public Works, working really hard to make sure the roads in town were safe and they were clean, and just really appreciate all the hard work they did over those 2 weekends.
Okay, thank you, Alderman Kane. Alderman Corey? Vice Mayor?
None.
Okay, I've already spoken my piece, so we'll move on to our ordinances. We'll start off with Ordinance 2602, approval on the second reading of Ordinance 2602. It was recommended for approval by the Planning Commission as Ordinance 25-20, an ordinance to amend the Farragut Code of Ordinances, Appendix A through Z, zoning, Chapter 3, Section 12, General Commercial District C1, subsection F, mixed-use town center. 3, building facade requirements to provide for new buildings to follow the town of Farragut architectural design standards. As amended, requirements for the town center suburbia remove references to the town center design requirements. Architectural Collaborative applicant.
Good evening. I'm Mark Shipley. I'll be presenting the next 4 ordinances for second reading. This one, Ordinance 2602, is an amendment to the zoning ordinance dealing with building facade requirements in the mixed-use town center. Currently, new buildings have to be 75% face brick on each of the 4 elevations. So what's proposed in this ordinance is to allow an applicant to average the face brick requirements over the 4 elevations. That's also what's currently provided for in our architectural design standards for the town center sub-area. So this amendment would bring the zoning ordinance into compatibility with architectural design requirements, and also provide applicants with a little more flexibility to maybe match older buildings in the case of a re-facade or a redevelopment. So when this was presented to the Planning Commission in December, they did unanimously recommend approval of Ordinance 26-02. It was also unanimously recommended for approval on first reading. There have been no changes to Ordinance 26-02 since first reading, and the motion is to approve Ordinance 2602 on second reading.
Move to approve.
Second.
Okay, Alderman LaCroix and Vice Mayor. Okay, we have any resident comments on this, Chrissy?
No, sir.
None? Okay, then we'll move on to discussion. Alderman Kane?
I have none.
Alderman LaCroix?
None.
Vice Mayor?
Pass.
I have none. Session closed. I will ask for a roll call vote, please.
Alderman Kane,
Yes.
Alderman LaCroy,
Yes.
Vice Mayor Meyer,
Yes.
and Mayor Williams.
Mayor Williams, yes. Okay, thank you. Let the record show ordinance 2602 has been approved on the second and final reading by roll call vote, February 12th, 2026, at approximately 6:11 p.m. Okay, next will be ordinance 26-03, approval of ordinance 2603 on the second reading that was recommended for approval by the Planning Commission as ordinance 25-21 as an ordinance to amend the Farragut Code of Ordinances, Appendix A, zoning, Chapter 3, 17, Office District O-1, subsection B, permitted principal accessory uses and structures to add interactive sports analysis services as permitted use to include a definition for interactive sports analysis services in Chapter 2 of zoning ordinances. Christian Miller, applicant.
Okay, ordinance 2603, as stated in the caption, amends the office zoning district to provide for a new use called interactive sports analysis services. That's kind of a low-impact use that, in this case, it's for golf simulation where you have to be a member, schedule a time to come in, and basically you practice whatever your skill set is. In this case, it was golf, but it could apply to other sporting activities. So this was a new use that we didn't really provide for in the office zone. But after reviewing this with the Planning Commission, they were comfortable with this being a use that would be a good fit in the office zoning district as a transition between commercial and residential. And so when that was presented to the Planning Commission in December, they did unanimously recommend approval of ordinance 26-03. This was also unanimously approved on first reading, and there have been no changes to this ordinance since first reading, and the motion is to approve ordinance 26-03 on second reading.
Move to approve 2603.
Second.
Okay, that would be Alderman LaCroy, Alderman Kane. We have any rest of comments on this one, Christian?
No, sir.
Okay, thank you. We'll start off again with Alderman Kane.
Mark, just to clarify, this is a situation where a person comes in and it's almost like they're using video analysis and so on to improve the way they play and so on. It's one person at a time. It's not, well, maybe one or two, I think is what the applicant said originally. But we're not going to see multiples of people there at one time, correct?
No, there shouldn't be, and it is, you have to schedule, you have to be a member. There's also a limitation in the ordinance on the size of the space. It's 3,500 square feet. And then there's some limitation on you can't have retail sales and food and alcohol, things like that. It's really intended to be a place where you schedule an appointment, you go in, and then you work on whatever it is you're working on. It's kind of almost like a professional service, which is a permitted use in the office.
Kind of like a PT or medical
Yeah.
facility.
Yeah, you're just kind of owning those skills and working on whatever it is you're practicing, so.
I know my golf game could use it.
Yeah, mine too. I did finally go to Top Golf the other day, and I was safe. I didn't hit anybody, luckily, so.
Okay, thank you, Alderman Kane. Alderman LaCroy?
No questions.
Vice Mayor? Pass. I have nothing as well. With discussion closed, I ask the town recorder for a roll call vote, please.
Alderman Kane,
Yes.
Alderman LaCroy,
Yes.
Vice Mayor Meyer,
Yes.
and Mayor Williams.
Mayor Williams, yes. Let the record show ordinance 2603 has been approved on the second and final reading by a 4-0 roll call vote, February 12th, 2026, at approximately 6:15 p.m. Okay, next will be ordinance 2604, approval on second reading, ordinance 2604 that has recommended for approval by the Planning Commission as ordinance 25-22 as an ordinance to amend the Farragut zoning map to rezone partial 05501, tax map 152, partial 055, tax map 152, that'd be 12232 Turkey Creek Road, from agriculture to general single-family residential, R2. Midtown legal applicant.
Yeah, this ordinance 2604 is a zoning map amendment, and it came about from an estate sale where a parcel that's currently recognized as one parcel by the town was sold as two different lots to two different property owners. So they're trying to get to a point where they can legally re-subdivide that parcel into two lots. In order to do that, currently the parcel is zoned agricultural, which is a 5-acre minimum lot size. So the goal of trying to rezone the property was, first of all, it makes the parcel more compliant with its size. You know, a 5-acre lot is not what's out there. This parcel is a little bit over 28,000 square feet. So that would bring it much more into compliance by rezoning it to R2 in terms of its existing size. It also lessens the amount of variances that we'd have to present to the Board of Zoning Appeals, because by dividing the parcel into two lots, we're making the parcel more non-conforming in terms of its lot size. But by rezoning it from agricultural to R2, the only remaining variance would be a variance on the lot size for the portion that's along the lake. And that's a little over 9,000 square feet, so that will still be under the 15,000 square feet that's required in R2, and that will be going to the Board of Zoning Appeals if this is rezoned. So that's kind of a background to how we got here with this. When this was presented for a recommendation at the Planning Commission meeting in December, they did unanimously recommend approval to the board for this rezoning. This was also unanimously approved on first reading. There have been no changes to ordinance 26-04 since first reading, and the motion is to approve ordinance 26-4 on second reading.
Vice Mayor and Alderman Kane. Okay, any raised comments on this one?
No.
None? Okay. Discussion, Alderman Kane,
I have none.
Alderman LaCroy,
I have none.
Vice Mayor.
Pass.
I have none either, just glad to get this going. Discussion closed. I'll ask Town Recorder for a roll call vote, please.
Alderman Kane.
Yes.
Alderman LaCroy.
Yes.
Vice Mayor Meyer.
Yes.
And Mayor Williams.
Mayor Williams, yes. Let the record show ordinance 2604 has been approved on the second and final reading by 4-0 roll call vote on February 12th, 2026 at approximately 6:19 p.m. Next will be ordinance 2605, approval of second reading of ordinance 2605 that was recommended for approval by the Planning Commission as ordinance 25-23 to amend the Farragut Code of Ordinances, Chapter 24, Subpart B, Article 3, Vested Rights and Development Standards by providing for updated provisions consistent with the recent amendments to the Tennessee Code Annotated, TCA, Town of Farragut Code applicant.
Yeah, ordinance 26-05 would replace the existing vested rights and development standards in our municipal code, which is in Chapter 24, with new language that would reflect fairly recent changes to the Tennessee Code dealing with what constitutes vesting. Vesting used to occur when something was approved. The state legislature changed that, and now it's when something is submitted. So communities have the opportunity to define what constitutes a substantially compliant submittal, and that's what we're doing in ordinance 26-05. We're also clarifying what constitutes a preliminary and a final development plan, consistent with the language that's used in the Tennessee Code. So that's the major changes in this particular ordinance. This was unanimously recommended to the board for approval in December by the Planning Commission, and it was also unanimously approved on first reading. There have been no changes to ordinance 26-05 since first reading, and the motion is to approve ordinance 26-05 on second reading.
Okay, Vice Mayor and Alderman Kane. Any rest of comments on this one? None. Okay, discussion. Alderman Kane.
Mark, just to clarify, when the final plans are submitted, the clock starts at that point for the vesting, correct? And then do we have is there a set time at that point, or is that something that's still in development?
Yeah, I mean, if it falls under our, what constitutes a submittal, then the vesting starts 3 years. It's good for 3 years. Now, if they don't do anything at all in the first 3 years, then it starts back over again. Yep.
Okay, thank you, Alderman Kane. Alderman LaCroy.
I have no questions.
Vice Mayor.
Pass.
I have none as well. With discussion closed, I ask the General Recorder for a roll call vote, please.
Alderman Kane.
Yes.
Alderman LaCroy.
Yes.
Vice Mayor Meyer.
Yes.
And Mayor Williams.
Mayor Williams, yes. Let the record show ordinance 2605 has been approved on the second and final reading by 4-0. Roll call vote on February 12th, 2026 at approximately 6:22 p.m. Okay, next will be resolutions. Looks like we have 2 resolutions to review and consider for approval tonight. Be Resolution R 26-03, approval of Resolution R 2603, social media policy. And I'll turn it over to Mr. Hale. Oh, I'm sorry, I didn't,
Hi, I'm the
sorry,
Communications Manager, Wendy Smith.
apologize.
I've been using social media to communicate with the town for 9 years since I've been here. A good portion of that time, it's been recommended by my professional organizations that we have a social media policy in place to address possible problems that can come up with social media. We don't have problems with social media happening in such a way that I would feel like posts need to be removed, with the exception of some fraudulent posts that get posted on Visit site, trying to get people to buy tickets for free events and that kind of thing. But I would like to have this policy in place just in case we change our minds.
Okay. Are you done?
I'm done.
Okay. Next, do we have anyone signed up to speak on this?
Yes, sir. Kim Parks.
Okay, Ms. Parks, would you like to step up to the podium and state your name, address? And I have to assume you have read our rules and regulations for speaking. And you have 3 minutes.
Kim Parks, Ferry Hills Boulevard. Mayor and Alderman, thank you for letting me speak tonight. Let's be clear what this policy is. This is not about manners. This is not about people calming down before they type. It's not about protecting feelings. It's about power and whether you actually have it. Under long-standing Tennessee law, municipalities are creature of statute. Under Dillon's rule, which this town's own attorney frequently cites, you only possess the authority expressly granted by General Assembly. Farragut is not a home rule municipality, so the Dillon's rule applies here. So I'm asking this board on the record, where in the Tennessee Code has a General Assembly granted you the authority to regulate or suppress lawful citizen speech in an online public forum? Because I have searched Title VI, I've searched elsewhere in the code, that authority does not exist. A resolution cannot manufacture power from the legislator never gave you. And even if you could point to a statute, which I know you can't, you would still be bound by the First Amendment. Last year, the United States Supreme Court made this crystal clear in Linked versus Freed when government officials, and this includes the entity itself, use social media in their official capacity, their moderation decisions are state action. That means the constitutional limits apply. Now here is the part that concerns me the most. This policy has already been enforced on social media. Comments have already been hidden, citizens have already been censored, and the board had not yet even voted on anything. We didn't even know anything about it. So let that sink in for all the citizens in this room. That is not just premature. It is governance without authority. You cannot implement first and authorize later. No one is arguing that true threats like doxing, illegal content should remain online. Nobody's arguing that. Those are already unlawful and have processes in place already available. The problem is the vague discretionary language, off-topic, misinformation, in the sole opinion of staff. Those are the exact kind of standards courts strike down because they allow only selective enforcement, which the town's communication manager has already been caught talking poorly about citizens in her emails to Louise Pavlin. So we all know she is not capable of being unbiased. Most citizens cannot afford to file a federal lawsuit every time their rights are violated. Constitutional protections are not meant to exist only for people with litigation budgets. It makes zero sense to have constitutional rights if you can't afford to fight them or fight for them. If the unspoken standard becomes, if you don't like it, sue us, then this board has forgotten its role. You are here to protect the citizens' rights that you represent, not dare them to enforce them. If you intend to move forward tonight, then identify the statute authority that grants you this power. Cite it clearly, because I'll be writing it down. Because if it does not exist, and I don't believe it does, then you are exceeding your authority, and that has consequences. Thank you.
Thank you, Ms. Sparks. Anyone else? No one else? Okay.
Can I respond to,
We'll move on, Mr. Hale.
let me, I got this suggestion that we didn't, while we have the authority, I don't think there's anywhere in TCA that says we have the authority to have a social media platform, but we have one. And I think that we also have the authority to regulate the use of our platform within the law. TCA 6-2-201, did you get that? Every municipality incorporated under this charter may, and it lists a total of 33 pretty specific categories. There's a lot of other authorizations throughout the code. I didn't have time today to search the whole code, but I found this one section, 22. Define, prohibit, abate, suppress, prevent, and regulate all acts, practices, conduct, businesses, occupations, callings, trades, uses of property, and all other things whatsoever detrimental or liable to be detrimental to the health, morals, comfort, safety, convenience, or welfare of the inhabitants of the municipality and exercise general police powers. That is a very broad category, but what this policy does is it is a policy for regulating other parties' rights to comment and post on social media platforms that the town sponsors. As the government, the town is required to observe and to not violate the First Amendment freedom of speech rights of those who communicate on its sponsored social media platforms where comments and posting are permitted. There is some speech, however, that the First Amendment does not protect. And the speech that the First Amendment not protect are the items that are specified in the policy as being the ones that we can rely upon in taking down posts. Defamation, threats, serious expressions of intent to commit an unlawful act or violence, spam, content that is not related to the subject matter of the post, encouragement of illegal activities, malware links, promotion of illegal discrimination, such as offensive and disparaging comments that target ethnic, rural, cultural, religious, or other groups protected by law. Content that purports to claim ownership of intellectual property rights contrary to the true ownership interest established by another party. Personally identifiable information about an individual, such as financial or healthcare data. None of these are protected by the First Amendment. The things that are protected by the First Amendment are things like disagreements over policy, public policy, or when the town is engaged in discrimination of applying the policy only to those who disagree with it. So the policy does not allow for the taking down of material just because the town disagrees with the person who is making the comment. So that's point number one. Point number two, if anybody in this town thinks that in the enforcement of our regulations, we don't have to rely upon the good judgment of our employees to carry out their duties in a lawful manner, you're kidding yourself. We rely on our employees every day to do the right thing. And so the suggestion, and I'm not saying that the speaker was accusing us of doing that, but the suggestion that somebody is doing something that's illegal, you don't do anything illegal. We wouldn't do anything illegal unless we took a post down that was because we disagreed with the content. And that has not been done, and there has not been any, or there hadn't been any evidence presented of what it was done, when it was done, and what was done. So again, if that's a problem, then we can address that. But that has nothing to do with this policy. This policy is designed to tell people who want to use our social media what they can and can't do without the town feeling obligated to take it down. Now, I think there's going to be some discussion about how this would be applied, how this policy would be applied. My thought is we probably would never take down anything unless it was something like what was described where earlier by Ms. Smith, where we advertise the art show, it's a free art show, and then some person posts on there, yeah, if you want to get your tickets, send me $50. Well, don't you think we ought to take that down if the tickets are free and they're not selling tickets? But so this is more complicated than just everything that put on there, we have to leave it up. We have to use some judgment so that our citizens don't get hammered by people who misuse the internet. So that would be my response. I think we do have plenty of authority under Tennessee statute to regulate this kind of activity as long as we don't violate somebody's constitutional rights by engaging in viewpoint discrimination.
Mr. Smoke, you have anything to add?
Mayor, I think the question that Tom alluded to and brought it up is, how does it get implemented? You know, how does the staff implement this? We have several staff that handle various pages of social media that we have all over the town. And so if they had a question on whether or not a post had some kind of issue with the social media policy and was violating the social media policy, the process internally would be to make sure they communicate that to our communications manager to make sure that they have another set of eyes look at it. And if they had any questions about whether or not it actually violated the policy, they'd come to me and talk to me about that. And if I had any questions if it violated the policy, then I would talk to Mr. Hale and get a legal opinion about that. So we'd want to make sure that we are not violating anyone's First Amendment rights through this policy. But I think that there are absolutely some egregious things that occur, like example that Ms. Smith gave earlier, that we need to be acting on. We do not want citizens to go out there and think that there is something that they need to pay for when they don't, and we don't take it down, and then now we're the problem for not taking that down, right? So those are the kind of situations when you certainly want to make sure we're protected by. But that is the internal process that we plan on using going forward, assuming that the policy gets implemented.
Yeah, before we deliberate, Mayor, if I may.
Go right ahead.
I received an email from one of the South Ward citizens, myself and another alderman, and I responded to the email several times, had a conversation with them. There was no deliberation between myself and or no deliberation at all, and they're just fact-finding. But since I did have a conversation on a board-related item that I'm about to vote on, I need to bring that up and notify that I had that email exchange.
Okay, sir. Anyone prior to discussion? Okay, if not, then.
I've been asked to look into this and to talk about it a little bit. This is the second time this has come up within the last little bit. And I think I need to go into a little detail so people understand what this is about. And I want to say part of the reason I think there's some confusion, and I wish Drew Burnett were here tonight because he was the other person that was copied on this email, which I'll get to specifically here in a minute, with Alderman LaCroix. They were sent an email by a citizen, which of course they can't control. They were sent that email together, and then when Mr. LaCroix responded, he responded to the citizen asking, well, explain a little more in detail what your objections are to this policy, and he copied Mr. Burnett on that. That's pretty clearly not deliberation. That's just passing information. It's not a violation of the Sunshine Law for the two of them to have had that communication. And a little later, Mr. LaCroix sent another email that he copied Mr. Burnett on, only I think because he had gotten the original stuff. And the confusion comes from, my advice has always been, just don't communicate, Alderman, or any other party related to the town that's on a board. Don't communicate by email with your other board members. Because if you do, you're susceptible to being accused of deliberating, even though you may not be deliberating, and then we have to go through the process of proving that you weren't deliberating. Same thing with having a casual meeting. If you bump into, go to dinner, or you bump into one of the aldermen outside of the office, that's not covered by the Sunshine Law. It's a specific exception. But if you have a conversation and somebody wants to accuse you of having done something wrong, then they've got a setting where they can do it. So my recommendation is just don't have those conversations. Well, because they violate Tom Hale's recommendation doesn't mean they violated the Sunshine Law. What it means is they have not done the overly oppressive thing that I ask them not to do, because I don't want them to have to be defending themselves every time they bump into one of the other people on the street. So I thought I'd better go into a little more detail about the Sunshine Law. That way we maybe won't have to come to this discussion every whip stitch. I'm looking at a book that is created by the Tennessee Coalition for Open Government, which is the activists in this area that try to advocate for citizens' rights. And this notebook is a very good attempt to explain for people that don't understand a lot about this what it means. The law states that a meeting occurs when governing body of a public body convenes, quote, to make a decision or to deliberate toward a decision on any matter. Some gatherings would not be considered a meeting under the law. For example, this is an example, one example. There are many examples. It says that a meeting does not include any off-site inspection of any project or program. That's in quotes, taken directly from the statute. It also says that a chance meeting of 2 or more members of the public body is not considered a meeting as defined by the law. So that chance meeting wouldn't be covered by the Sunshine Law. But the statute goes on in very strong language to say, quote, no such chance meeting, informal assemblage, or electronic communication shall be used to decide or deliberate public business in circumvention of the spirit and the requirements of this part. So that pretty clearly says email would be included if you're having email communication or even phone communication. If you were deliberating, that becomes the real issue. There's been some confusion in this state because the courts have never been real clear about what it means to deliberate. And that's the problem. It's not that you're talking about public business, as you'll see in just a minute. It's about, are you deliberating toward a decision? That's what is prohibited from being done outside of the public meeting. In 2012, the Tennessee Attorney General issued a legal opinion that offered some clear guidance that nothing in the law prohibits 2 members of a governing body from speaking with each other outside a properly announced public meeting. They can even dine together. They simply should refrain from deliberations. The opinion was issued by Robert Cooper, who at the time was the Tennessee Attorney General. And he talks about the kinds of things that this deliberation concept raises. And they refer to their decisions of the Tennessee Court of Appeals are instructive on the broad question of under what circumstances members of the governing body can privately discuss public business without violating the Open Meetings Act. They cite a particular case, Tyler versus Henry County, and they describe it this way. The act was not violated when 4 of 5 board members were confronted after a regular meeting by disgruntled employees and heard their grievances, but did not decide to terminate the plaintiff who was the subject of their grievances until after a hearing on certain charges that occurred later. There's another opinion, they say. Telephone conversations and chance meetings between city councilmen prior to meeting on such zoning matter was considered, did not violate act when participants did not make a decision, solicit commitments, or weigh or consider reasons for and against matter with a view toward making a choice or determination. The most recent decision cited by the Attorney General was Johnston versus Metropolitan Government, in which the Court of Appeals addressed the issue of whether emails among council members were used to, quote, deliberate public business, end quote, in contravention of the Open Meetings Act. The court first noted that the act did not require an intent to circumvent the act in order to find a violation, i.e., a violation of Open Meetings Act can occur inadvertently if the electronic communication has the effect of circumventing the spirit or requirements of the act. The court then examined whether emails constituted deliberation, noting that the term deliberate had previously been defined as to examine and consult in order to form an opinion, to weigh arguments for and against a proposed course of action. And there's citations to cases where that was said. The court examined 3 categories of emails. The first category appeared to be merely the dissemination of information, such as emails from affected residents stating their position that had been forwarded to council members. The second category included emails between the individual council members discussing strategy for gaining passage of the legislation in question. The court found that neither of these emails constituted deliberation, i.e., weighing arguments for or against a proposed course of action. The third category, however, included emails between council members in which they were clearly weighing arguments for and against the proposed legislation. These emails, most of which were copied to all board members, were found to mirror the type of debate and reciprocal attempts at persuasion that would be expected to take place at a council meeting in the presence of the public and the council as a whole. Accordingly, the Court of Appeals found that these emails were electronic communications used to deliberate public business in circumvention of the spirit or requirements of the Open Meetings Act. In light of the above authority, the private discussion of public business at a meal by a number of members of a governing body would certainly present a potential issue of whether a chance meeting or informal assemblage was used to decide or deliberate public business in circumvention of the Public Meetings Act. This is the part that I really want you to understand. When a violation occurred, whether a violation occurred would depend upon what was said and what transpired during the meeting. Thus, while the case law does not lend itself to hard and fast rules because the decisions are so fact-dependent, some cautionary advice readily appears. While two or more members may share a meal together in public business where public business is discussed, such discussion should not constitute deliberations, which term has been defined to mean to, quote, examine and consult in order to form an opinion, end quote, or to weigh arguments for and against a proposed course of action. So the real question is whether there was deliberation. I've told you that Mr. LaCroix received an email from this citizen who copied Mr. Burnett, and he responded. The second response that Mr. LaCroix gave, he wrote back to the citizen. Thank you for providing clarity. Let's see, is this the right one? Thank you for providing clarity to your concerns. Excellent points. And I will ask these questions, specifically the process and procedures involved in determining whether a violation has occurred and the remedy. I believe requiring board review is an excellent idea. It is not timely enough for day-to-day operations. I think a procedure document detailing the steps from identification of a potential violation, paren staff, close paren, decision to remove, paren management, close paren, and review of all adverse actions by the elected officials and attorney would be prudent. Thanks again for taking the time to communicate with us. My view of that is there's clearly no deliberation in either of those. There was no discussion. I mean, Alderman LaCroix was communicating with the citizen, and Mr. Burnett was copied on that. There was really no weighing of alternatives. There was a statement that he would ask the questions, and there was a statement that he thought it might be a good idea to have a certain procedure. If there was a violation, I don't think there was a violation, but if there was a violation, the law is that it has now been cured by the fact that we have explained exactly what was said in the emails, and everybody in the public now, before we've deliberated, knows what was said. And I think it's pretty sorry, and I'm not speaking of you. I think that if people can't look at this fact circumstance and say, these people are up here trying to do the best they can do, and they get contacted by citizens and they try to respond and be responsive. And, it's not like Joe said, yeah, I'm really much in favor of this, and I think we need to do this, and it needs to happen. And, if in fact that it was considered deliberations, that second email, then it's now been cured according to the law. I think there's actually another section of this. There's a case. Although the court found the school board deliberated on a rezoning plan at a retreat in violation of the Open Meetings Act, it ruled that the school board's eventual vote was legal. The court reasoned the actions of the school board after the retreat, but before the formal vote, fixed the violation. The board scheduled a public meeting, gave adequate notice, and then allowed a 3-hour public debate and question and answer session on the issue. The court said in its Nice versus Paris Special School District, the purpose of the act is satisfied if the ultimate decision is made in accordance with the Public Meetings Act, and if it is a new and substantial reconsideration of the issues involved in which the public is afforded ample opportunity to know the facts and to be heard with reference to the matters at issue. It's not, the court notes, it's not to punish people. It is to make sure that the deliberations occur in public. They have now occurred in public. Everybody knows more than they probably ever wanted to know about this set of emails and in the Open Meetings Act. But hopefully we can avoid having to spend everybody's time in explaining things that we really try to handle without wasting everybody's time. But sometimes you can't avoid it. You have to. That's all I have.
Mr. Mayor, I have a question of privilege.
Okay, you were fixing to be called on.
Okay, I appreciate that. Mr. Hale, you stated that chance meetings, as you read through there, are permissible as long as there's not a deliberation. I was censured for having a 7-word conversation with Alderman White. Not an email chain, not emails back and forth with 2 aldermen and a citizen. I'd like to hear what the first part of the email actually had to say too from the citizen. And I think we need to have a full investigation and discussion on this, because I believe you also stated that because we had this conversation today that the whole issue was cured. We had this same type of conversation with mine on an item that still has not come up for vote, and you stated that mine was not cured.
Yeah, in your situation, you wrote to the newspaper and told them that you and Mr. White had a conversation and you had agreed how you were going to vote on a particular issue that was coming before this board. That's totally different than what we have here.
I still have to disagree with you, because the conversation was, I don't like it and neither do I. That was the whole conversation between Alderman White and myself. That was it.
Well, then you misreported what you wrote to the newspaper, because the newspaper had your letter in there that you wrote, in which you told the newspaper that got published in the newspaper that you all had this conversation and reached this agreement.
There was nothing in there about a conversation. It was a chance meeting, and I specifically said what the conversation was. I truly believe that you have decided here that this needs to go away, so there's not an example made, but I was made an example of.
Well, if anything was violated, it was that they didn't follow my recommendation and not copy each other on an email that wasn't even about the merits of the subject matter that we're here to vote on.
Well, Mr. LaCroix, being in the tech field, knows that he can respond back and take Mr. Brunette off of the email, and he chose not to. Anybody knows that when you reply to somebody, you can reply all, or you can reply specifically to a person, and he chose not to. And
so he violated Tom Hale's recommendation. That's not a violation of the law.
I believe he also did, based on how what you in our discussion with me. But you just stated here that because we've had this conversation, and Alderman LaCroix brought it up, that any violation that may have occurred was cured. I brought it up, and we had a discussion here almost the same exact way, and you explained everything to the public and everybody else. And then you turned around and you censured myself and David White.
I just think it was a totally different situation that you published in the newspaper and told everybody in town that you and Mr. White had reached this agreement. And I felt like we had no choice but to go into a little more detail. That was not what we
You
had here.
continued on based on public comment after that by one individual in this town, and you fell right along with that public comment after that. You and I had a phone conversation where you actually told me, after you read through the whole thing, that you truly believe that we could cure this by having a discussion before that item ever came up to vote. And that item still has not been in front of this board.
Well, I think you could cure it. It hadn't come back. It can be cured, but it never has been voted on because for reasons I don't really know, that's not part of my job. But we hadn't voted on, we could still cure it. The issue wasn't whether we could cure it or not. We could still cure it. The issue was it was published in the newspaper and it was basically an admission that we had violated the Sunshine Law and we needed to make a statement. If we expect our citizens to follow all of our regulations, we have to be able to follow them ourselves.
So curing is bringing up the violation and discussing it ahead of time, correct? That's roughly how you described it.
It is at the time of the vote, when you're getting ready to vote on it.
So why would we even do a censure then why wouldn't we have that discussion at the time of the vote and then we cure it? Instead, you decided to censure me on something that we've never voted on. And the way you explained it was, if we have this discussion now and you talk about it and we air it and we allow everybody to know what happened, then it's cured. But then you turned around 2 weeks later and you censured me.
Well, why shouldn't you be censured if you wrote an article to the newspaper explaining that you had violated the Sunshine Law?
I never wrote anything and never said I violated the Sunshine Law. Never, ever in the newspaper said that.
We can go back and look at the letters. We've got them in the file, and we can do that. And if that issue ever comes up again, then we probably need to have a cure. But
Haven't we already done that by discussing it when we did?
well, maybe we have now, but we're not even talking about the same subject matter.
Yeah.
Okay, next up will be Alderman LaCroix.
I'm sorry. All right, so part of that conversation was talking to the constituents. I talked to about 10 separate people. They had pretty much the same concerns. One person was adamantly against this policy regardless, and it was based on First Amendment concerns. Every other person that I talked to was in favor of the policy itself, especially for things that is, completely understandable, defamation, threats, illegal activity, malware, promotion of discrimination, Title VII stuff, or is it Title IX, whatever, intellectual property rights, and PII. So the one that got everybody is the spam. Everybody wanted to know what spam was. And they were, once again, worried about, the First Amendment rights and the removal of spam. So some of the questions were, what's the procedure for removing posts that are violating this policy? David kind of went into that a little bit. Who decides? Who decides who's going to remove that post? Is there a review process? Clarification on spam. What is spam? And the one that I kind of think about is, there's a post out there that is made by the town on some event that we're having, cookies and hot cocoa with Santa. And I go in there and post, well, I want some hot cookies. And, somebody comes out there and blasts me, and calls me fat, dumb, and ugly. By the way, this happened, and my wife stood up for me, and she said that I wasn't dumb, and I was very happy for that. So if someone said, you're fat, dumb, and ugly, is that supposed to be removed? Is that spam? And if we could get clarification on that, what is going to be spam, what's not going to be spam? And then the last thing is there an appeal process? Is there an appeal process? What does that process look like? how do we make sure that we as a board elected body, we're not, or the town as a governmental body is not suppressing somebody's rights. So those are my questions.
Okay, thank you, Alderman Croy. Vice Mayor?
I do think there needs to be an appeal process outlined in the policy somehow. And Joe, you answered my question, I think. I wasn't sure what spam was either, and that was the only bullet point that was a little bit confusing to me. I'm comfortable with the majority of it simply because the other bullet points are part of topics that are not protected by the First Amendment, so I'm okay with that. I still think there's a little bit of confusion on spam, and like I said, I think there needs to be some kind of appeal process.
Okay, thank you. There is some confusion on spam. I think it kind of crosses over in some cases to defamation. And I think what Joe just explained was more along that line as opposed to, not necessarily him, but maybe someone else that was in a reference. So, and I agree with everyone that there should be an appellate process, because if the person, another thing is, a lot of times, the social media site takes things down. We have no control over that. And so it's a thing where if that happens and it's gone, we'll probably get accused of it, okay? But that won't be the case. So at that point, there might be a reason for an appellate to understand that we did not take it down, that possibly the site itself did. And I guess I have to look to the people that spend a lot of time doing that. So other than that.
Mr. Mayor.
Oh, you want?
Based on what you just said, I do have a question for David.
For
you don't
David?
mind. Yeah, for David.
Okay, go right ahead.
Will there be any kind of a report generated that tells us if we had issues and how they were handled and so on? Is that something we can do, or is that something that you've thought about?
Absolutely. So this is probably a very rare occurrence this is going to happen, right? We would screenshot, if we had to take something down, we'd screenshot what that comment was before we took it down, so that way we would know exactly what it was. And if the board wanted to see something monthly or quarterly or however often it is to report back and let you know what we took down, we'd be happy to do that as well. You're correct. There's not a appeal process in this current policy. What we would do, though, is if we took something down and somebody had a question about why it was taken down, we would provide the policy to them and let them know that they violated the policy. That's why it was. And they could certainly amend their post and make it compliant with the policy to be able to put it back in there if they wanted to put a similar but maybe different post that did meet the policy requirements. So that's the way internally that we would process those at the current time.
That would also answer the question if we were actually the one that took it down, or if someone else did that was out of our control, right?
Correct. We would make sure that anything that we took down, we would have a screenshot and keep that, so we would know what those are. Yeah.
Okay, thank you, David. Anything else, Alderman King?
Actually, Wendy, is she still here?
Yeah, she's right there.
Okay, there you are. Just
come on up.
Would we get notified if, say, Facebook removed a post on their own? Is there a way we will know if they did it versus us?
No, I have never taken down a post, and I hear that posts are gone, so I can only assume that.
No, my question is, so let's say, like we talked about here, let's say Instagram or Facebook, the post violated their policy, and they automatically remove it. Is that something that you get notified of based off of our account? I didn't know if you get a notification based on your Facebook account that post XYZ was removed, kind of thing.
Sounds like magic.
Yeah.
Okay, sounds like we have discussed this.
Mayor,
Somebody else.
I'm sorry. I just wanted to, we had a provision we'd like the board to look at amending in the social media policy. And it's at the very end, the very last paragraph. Currently reads, comments may be disabled on public service announcements made through social media, including information about public safety and emergency situations. We thought it would be simpler, and I think we talked with our MTAS consultants, attorneys with MTAS, and they recommended that we change that language to the town has the authority to disable comments on any of its social media platforms. So that would be the only amendment that we would propose this evening as part of the approval process for Resolution R-26-03.
Okay, with that said, I'll need a motion.
Can I make one more
Oh,
comment about?
Okay, Mr. Hill, go right
I
ahead.
forgot to make this point. We are adopting a policy, possibly. You don't violate the law by adopting a policy. You may violate the law by how you implement the policy. So the real issue about violating something would result if we adopt a policy and then we ignore it and we do something that the law says we can't do. The policy can't outline every aspect of the First Amendment jurisprudence. There's a lot of discretion and judgment that has to be involved. So I would hope that people would understand that we've not, the only post I know that's been taken down by the town staff was the one where the people were trying to sell tickets for a booth at a show that they didn't have anything to do with. They were trying to scam money off of our citizens. Otherwise, I'm not aware of any other posts or anything else that have been taken down. And I don't know of anybody on the staff that's aware of any. So, again, adopting this policy isn't a violation of the law. It's how we implement it that would be the violation if we didn't do it the right way.
Okay. Anything else? If not, then I will need a motion that includes the change in the, in red. It's at the bottom of the page there.
I move to approve with the changes noted in red text.
Okay. I'll second that. And in this case, again, I'll ask for a roll call vote, please.
Alderman Kane.
No.
Alderman LaCroy.
Yes.
Vice Mayor Meyer.
Yes.
And Mayor Williams.
Mayor William, yes. Thank you. Let the record show that the resolution R-26-03 amended with the one sentence change has been approved by a 3-to-1 vote on February 12th, 2026 at approximately 7:08 p.m. Okay, next will be Resolution R-26-04, approval of Resolution R-26-04, revised fee schedule for fiscal year 2026.
Good evening. I'm Tessa Cortez, Finance Director. The purpose of this resolution is to bring forth proposed changes to the schedule of fees for fiscal year 25-26. The fees consist of changing the McPhee tennis court fee from $10 to $5 and adding Campbell Station in rental fees. Additionally, a 10% employee discount for gift shop merchandise has been added. The proposed motion is to approve Resolution R-2604, the revised fee schedule for fiscal year 2026.
Move to approve.
Second.
Okay, Vice Mayor and Alderman Kane. Do we have anyone signed up to speak on this? None? Okay, then Alderman Kane, you have anything to add on this?
No comments.
Okay, Alderman LaCroy.
I have no questions.
Okay, Vice Mayor.
Pass.
I have nothing. Discussion closed. I'll ask if you're in favor, please say yes.
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 Any noes? Okay, let the record show that Resolution R 26-04 has been approved.
Thank
February
you.
12th, 2026, at approximately 7:10 PM. Thank you. Okay, next we have 3 items to consider for approval tonight. One of them is approval of reappointment to Visual Resources Review Board.
Mayor, we received a request from Jonathan Francis. He had to miss 3 meetings due to some significant out-of-state travel for work and a medical emergency. Those issues have been resolved, and he is requesting to be reappointed to the Visual Resources Review Board, and the motion is to approve the reappointment of Jonathan Francis to the Visual Resources Review Board.
Motion to approve.
Second.
That would be Alderman Kane and Vice Mayor.
Yes.
Yes. Okay. Looks like that would be unanimous, and let the record show the request has been approved. Okay, 4-0. Okay, next will be approval of professional services agreements with LDS Engineering, Inc. for engineering and design of the Red Mill Dam parking lot and trailhead.
Evening, Board. This item for your consideration is regarding the Red Mill Dam and trailhead and parking lot. The town of Farragut took possession of the Red Mill Dam, which is located in the parcel of land at the corner of Concord and Turkey Creek in August of 2020. Design and development of a parking lot and trailhead has been on future CIP plans since that time. In an effort to showcase this beautiful piece of property, the town has been researching different possible options for access to the dam area. The project will feature a 10-stall parking lot and pathway leading to the trailhead area adjacent to the Red Mill Dam itself. The scope expanded due to FUD requesting us to build our own parking area instead of using their open space at the corner, which was our original plan. Staff advertised an RFQ in December and selected LDA Engineering to conduct the engineering, design, and bid selection process for the Red Mill Dam project. The town has had several successful projects with LDA in the past. LDA's follow-up proposal is a lump sum fee of $61,700, which staff feels is fair considering the overall scope and permitting required for this project. Staff recommends approval of LDA Engineering, Inc. for the design and engineering services for the Red Mill Dam parking lot and trailhead.
Okay, we've got a motion by the Vice Mayor, second by Alderman Kane. And do we have anyone signed up to talk about the Red Mill Dam? We do not, okay. Then I will ask Alderman Burnett if you have any comment on that.
No questions, Mayor.
Okay, Alderman Kane,
No questions.
I have no questions.
Vice Mayor.
Pass.
Have done as well, although I'm glad we're finally going to get this pocket park in motion. So with discussion closed, I ask if in favor, please say yes.
Yes.
Okay, any noes? Let the record show the request has been approved as requested. Okay. Sorry, next will be citizen comments. Do we have people signed up for that tonight?
Yes, sir, we have 2. First, we have Ralph Hawes.
Sir, you have to come down front and state your name and address, and I have to assume you've read the protocol, okay? And you have 3 minutes, sir.
Oh, sorry about that. Didn't get that on there. I just have actually 4 points I just need to get across, and I'll do it very quickly because I have 3 minutes. But first off, thank you all for what you do. Appreciate it. This has been very interesting sitting here watching you all tonight go through your process that you go through and enjoy that. So I'm going to get quickly to my reasons for being here tonight. And I think everybody's aware of this. Mail security in the community with what's going on over here at the post office. I am one of those people that have been impacted by that. And I spoke with Farragut Press last week, and I was finally glad to see it on the front cover of the paper. I know everybody's pretty aware of it. It's a bigger issue than what I've had several of my friends that have been hit by it. I understand this is a federal government facility over here, but I would like to know what the town of Farragut and what you all are doing working with the federal government to make sure that we can get back a post office that we feel comfortable to take a check into. And if we have to mail a check, that's number one. Number two, I don't believe, unless I've missed it, we've lost our Knox County Sheriff's satellite office out here. I would love to see some type of situation where you all are discussing that. I've never felt, and I'm a little bit scared talking to you guys, I've never felt more unsafe in this community. I've lived here for 31 years, and there's a lot going on, and just like to see that happen. I've noticed going through, I'm retired, going down Kingston Pike when schools are letting out, not necessarily in the primary school, but definitely down by the high school and everything, there needs to be a police presence in the afternoon. I watched a young lady almost get hit by a car the other day when they were going home. Last thing, I live at 12216 West Ashton Court. I live in Andover Place subdivision. I am retired. I am in there every day. No less than 5 times in the last probably 2 months have I been approached in my yard by people walking through my neighborhood wanting to work on my house, paint my house. There are no cars, there are no trucks, they're just walking through. We have no solicitation, we have neighborhood watch. We have a lot of people that work during the day. I used to do that. Most of us have cameras. Everything that's gone on in Arizona lately, just don't feel good about things. And I haven't seen a lot of what I brought up come up, and I would like to put those on your minds to be able to discuss. I think there are some safety and security issues that need to be looked at in our community. We have a beautiful community. I know we all work, and you guys all work very hard to make this a wonderful place to live. But I do think the gentleman that's back here today, we need to see more security and more presence of the Knox County Sheriff Department out here. And we need to be able to go. My grandfather was a postmaster in Allentown, Pennsylvania. This disgusts me that we can't mail. I had discussion with Dot LaMarche at the gym. She can't mail things through our mail system. She doesn't do it. That cannot happen. And I understand, just in talking to the detective, with what happened with my checks, it's not just here. It's at the main post office too. But I do believe, and I have a question, do we have any cameras looking over there? Because I talked to Tammy Cheek at the paper when she did the article. I said, are you aware if there are any cameras over there that are capturing people that are going through there? And she said, inside the facility there are cameras. There are not cameras facing out into the parking lot. And I said, thank you for putting that in there, because I think, and I noticed at Christmas time too, when I would go over there to mail packages to family away, there's people putting and stuffing, and we've all seen it, those outside post boxes getting filled to the brim, that they're not necessarily aware of what's going on. But I think that's long overdue to be looked at. Again, I know that's a federal institution over there, but I would like to know what the town of Farragut is helping. And I did witness when I was over there, a gentleman come walking through the parking lot, going through the mailboxes, not going through them, but walking around them continuously. He came up to the post office as we were standing in there, walked back to the boxes, and then he walked back into the woods behind the Admiral Farragut statue right here. If we had a camera, you probably could have ID'd that person. And what were they doing wandering around the mailboxes? They weren't putting mail in. I watched it. Thank you for your time. Thank you. I know that was a lot in 3 minutes, and I know my time is way up. But I will be glad to come back and discuss this at any time. Thank you.
Okay, thank you. David, do you want to comment on any of this at the moment, or? Oh, we got another one?
Yes, sir.
Oh, okay. I'm
Kim
sorry.
Parks.
Okay.
Kim Parks, Farragut Hills Boulevard. Good evening, members of the public, mayor, alderman. Thank you for giving me the floor. Let me start with the good news. Senator Richard Briggs confirmed to me directly that the eminent domain bill has been withdrawn and he will not be supporting it. That did not happen because leadership here in Farragut protected its residents. It happened because the citizens caught it. Citizens read the documents, citizens pulled the court records, citizens made the calls, and residents exposed what was happening. And despite being labeled a small group by the committee member Benson Scott, this effort involved thousands of engaged people across Farragut and Knox County. And I am very proud of this community for doing so. But now we need to talk about the uncomfortable part. Because in my opinion, what happened here represents a serious failure of leadership and transparency in Farragut. Here's what the public records show. The town retained outside counsel related to the Turkey Creek Greenway before they were even sued. Then the town administrator, David Smoke, instructed the project be renamed from Turkey Creek Greenway to Turkey Creek Multimodal Improvement Project. Then efforts began to seek an attorney general opinion. Then conversations occurred at the state level with Senator Briggs and the town and Mayor Williams. Then Senator Briggs introduced legislation that would redefine greenways as transportation infrastructure, making eminent domain easier to use. That sequence is not random. In my opinion, it was coordinated. And that matters because reclassifying a greenway as multimodal transportation lowers the legal threshold for taking private property. That's not semantics, it's not strategy. When this board approved outside counsel, the public was not told that lobbying for changes to state law was part of the plan. There was no public notice, no public input, no disclosure. In my opinion, that's a transparency failure. Meeting minutes and public social media statements further show coordination between David Smoke, Mayor Williams, and Planning Commissioner Louise Poplin. When multiple officials who serve on the same boards coordinate actions of this magnitude outside of public meetings, it raises serious Open Meetings Act concerns. And I want to be very clear. This does not look like one employee acting alone. And in my opinion, this appears to be a coordinated effort between multiple people. It has been stated, including in conversations with Senator Briggs, that this bill was brought forward at the request of the town, Ron Williams and Louise Poplin. The documentation aligns with that statement. If that is inaccurate, or if that is accurate, then in my opinion, this body owes the public accountability, and those involved should be formally reviewed and censored. Because government should never be working behind the scenes to make it easier to take citizens' property. That's not why Farragut was founded.
You're done.
You guys let that guy finish.
Yeah, I let you finish before too, but what you're saying is your opinion. That's fine. You've stated it. You can step down now.
No, you cannot do that to me. You cannot do that to me. You should let me finish like everybody else.
Please. Please step down.
This is ridiculous. You guys should let me finish, just like you let everybody else finish.
I let you finish before.
Yeah.
And I let him finish before, but when you start repeating yourself, then you need to step down. Yeah, you were. Mr. Smoke?
Let me start with, I think Mr. Howells had a couple questions about some of the things he brought up. Obviously, the mail security at the post office is really difficult for us to try to interject and do things with, but we can certainly have some conversations with the post office and see if there's anything we may be able to do. Certainly, the sheriff's department is going to be your best bet on that. We have tried trying to keep a precinct for the Knox County Sheriff's Office in our town. The mayor and I know, have met with the sheriff's department on this on numerous occasions, had conversations with them, and unfortunately, they've decided to move down to Cedar Bluff. And so that's been an unfortunate situation that we would love to have that presence here. The sheriff's department's been here for over 20 years in our town, had an office here in Town Hall at one point. Then moved over to Turkey Creek, had a great presence there, did a great job. Loved having them there. So certainly that's something we're going to continue to work on, hopefully with the next sheriff whenever that time comes. And then we do have solicitation permitting that happens through the town and also with Knox County. Sometimes they go straight to the county, and we don't have any control over that. But if they have a solicitation permit, they're allowed to come into those neighborhoods. So that's an issue and a situation that is difficult sometimes to regulate, certainly on our end of things, and even the sheriff's department as well.
Can I add something to that quickly? I know, I was just gonna say, we have no solicitation policy in our neighborhood. We are having a hard.
Yeah, you told us about that, and we're aware of it too. We have it, most all of the neighborhoods that have HOAs have that as well.
Right, and so I know Ms. Parks brought up some various things. One of the things I would say, though, is that, part of my job is when situations occur, like they did a couple years ago with the law changing, and we were told many times by the plaintiff's attorney that Mr. Hale had a conflict in that situation. I thought no better person to go ask for an opinion about that than the Attorney General of the state of Tennessee, because that's the person that gives all the opinions in the state of Tennessee. But we had to hire an outside counsel to help us with giving that opinion to Representative Zachary to help us out, to at least get the opinion. Of course, then we were sued before the opinion could come, and the Attorney General backed out of that. And so that's all that was. Our attorney has not been lobbying anyone on our behalf. He simply helped us with a letter in order to get to the Attorney General. So it's a simple process. It can be complicated because people don't understand that I am not allowed, the mayor's not allowed, the board's not allowed to ask an opinion of the Attorney General. It has to come from a state legislator, and that's exactly what we did. So with that, I have some maybe good news about things coming up here shortly. That is on February 13th, we've got Galentine's Day. Build your own bouquet from 4 to 6 p.m. at Campbell Station Inn. Anyone age 16 and up is welcome to attend. It's $10 per person. We also have on February 13th the Just Dance Glow in the Dark Dance Party from 6:30 to 7:30 at the Farragut Community Center. Again, all ages, and it's free. We also have on February 21st the Songwriter Showcase from 6 to 8 p.m. at the Wild Wing Cafe. That'll be a great event back at the Wild Wing Cafe again. And then on February 21st and 22nd, there is the Town of Farragut Quilt Show. That's going to be from 8 o'clock in the morning to 5 p.m. on Saturday and 1 o'clock to 4 p.m. on Sunday at the Farragut Community Center. That's all I have to report, Mayor.
Okay, before we go to Mr. Hale, I think Alderman Kane had something else that he had on his mind over here.
Yeah, this would fall into the citizen comments. I received an email today at 3:30 in the 3:36 in the afternoon from Eric Johnson, who is one of the founders of our town. And he sent this to me. He said, it's addressed to me. It says, I appreciate your willingness to discuss roads and streets, sidewalks, and financial issues. My intent was to attend the BOMA meeting tonight, but I'm having some serious back problems and I'm unable to walk at the moment. If I cannot get to the meeting, would you please read this message to the board? These are my opinions only, and I'm not implying that you agree or disagree by reading my message. Do you care if I read it? Okay. It says, so it's from Eric Johnson. Subject, walkways, sidewalks, eminent domain. Recently, there's much publicity about condemning property to build sidewalks or walkways. I know government has the authority by eminent domain for roads, utilities, and schools, but I think the use of eminent domains for sidewalks and walkways is wrong. I don't know if it's legal, but I do believe it's wrong except for sidewalks for a school. For the past several years, I keep hearing many times, this is what the founders wanted, or this is what the founders would do. As one of 7 of the founders, I can verify those statements are not always true. The founders were 7 people with some very important common opinions, but also some very differing opinions. Unfortunately, there are only 3 of us left. I can assure you all, or at least almost all of the founders, did not support condemning property for walkways. We tried to be very respectful of our property owners. The first walkway constructed by the town was along Turkey Creek Road 45 years ago. It ended at the sharp curve because it could not be built due to the topographical restraints. It was too costly and too much damage would have been done to several residential properties. Now the town is proposing obtaining property using eminent domain and building a very expensive walkway. Farragut is not an urban environment where people walk to work, stores, restaurants, and schools. Almost all of us use our walkways for recreation. Sidewalks and walkways are valuable but not necessary except adjacent to schools. Our roads and streets are indeed in need of more repair and resurfacing than can be done with the currently budgeted funds. I suggest you use those funds for roads and streets. On August 12th, 2025, I sent an email with my concerns to everyone on the BOMA. I was not confrontational, just expressing a citizen's opinion. Only you, Alderman Kane, responded. I will end with this historical quote by a great man. It says, Ronald Reagan, government has an inborn tendency to grow, and let to itself, it will grow beyond the control of the people. Only constant complaint by the people would inhibit growth. And again, it was signed Eric Johnson.
Okay, thank you. In that case, Mr. Eric Johnson called me personally.
Okay, good.
Instead of me sending him a reply, he actually called me. And he talked about eminent domain. And I told him there is nothing been mentioned ever about taking anyone's property. Okay, that's never been mentioned. That has been fabricated by the people in the social media realm that says that that's what we're going to do, and we were sued for that. Lady sitting right back there that did it. And so, folks, everybody's got an opinion, and that one right there, Eric is a founder that disagreed with some of the others, but he had the right to. That was his right. I think he would not turn down doing this in a school zone where we have kids walking to school. We've got a piece of legislation that's down there right now to approve robots running on our sidewalks and in the road. And if that happens, then we're going to have robots that can run 20 miles an hour. I'm not kidding you.
I know. It happens at UT every day.
And if that happens in our town, we're going to have a real issue. But what they're trying to do is preempt government from stopping stuff like that, from stopping robots running in our school zones. And for folks that support that, then they must not have kids. That's all I can say. That's all I got. Anyone else? If not, we'll move on to Mr. Hale.
You know, lawyers like to talk a lot, but I think I've already spoken enough tonight, so I'll not have any more report.
Okay, with that said, thank you, Tom. It's approximately 7:33 p.m. without objection. February 12th, 2026, Farragut Board and Mayor and Alderman meeting is now